a few key points during my introduction time. There's one I actually left out. I think I left it out actually intentionally because it's sometimes what we call the elephant in the room. And in this case, the elephant in the room when you go into the distributed world is, you can say, the governance, the legal compliance, etc. Because in the traditional banking world, everything is structured, everything is based on rules and regulations. Simple things like KYC, know your own customer, AML, anti-money laundering, and then the various regulations that countries introduce like FACTA and so on. It's a very long list. And of course, the people that come in with blockchain, DeFi, and all this, no, all these we don't need. We are creating a parallel world. But, you know, when you create parallel worlds, it's like the positive and the negative. And as if you study a bit of physics, when the two collide, it can make quite a few sparkles. So in this case, we need to find how we address the challenges of legal aspects in DeFi. I mean, some projects don't have a founder, don't have an address, don't even have a website other than the DAO that, or the DApp that is actually running in this virtual world. So people want to know who is behind, what is the compliance as you onboard users and so on. What is the, yes, everything is audible in the blockchain, but not everybody wants everything to either be fully anonymous or even pseudo-anonymous, for lack of a better word. So here we have a Baiba Broka, and I hope I do justice to the term because I am not versed in Latvian language yet. She's part of the governing council of UNIDROIT. I guess it's the French, droit is the French word for legal aspects. She's also the former finance minister of Latvia, and she's going to give us the perspective of the elephant in the room, in this case, the legal aspects, compliance, legislation, challenges associated with DeFi. So I'm sure this promises to be quite interesting because it's looking at things from a completely different perspective. Thank you, and please, Baiba, welcome.
Good morning, everyone. So first of all, I would like to express my gratitude to Agora Group, to Hadi for this great opportunity and honor to have the chance to present some of my findings regarding legal regulation. And also special gratitude goes to Ahmed, very special friend who encouraged me and invited me to speak. So a little bit change, I'm a former Minister of Justice in Latvia, so I'm a lawyer. And mainly working in a private law, international business law, and also in capital markets. So technologies, it's actually not the first time when we are talking about technological revolution in market, in finance. So if we go back to 1958, when the first credit card of American Express company was released, it was considered a revolution. Everybody was shocked. And it was a question of the society. Can we trust to this new credit card, this small piece of plastic, which if we look today, probably every one of you have few of them, very beautiful designed. And then we see that actually if the main idea of any technological revolution or introduction or innovation is the main goal is how to serve customer better. And today we know that this beautiful plastic card can make us very, very happy. Or if it's not working, it can really disappoint us, annoy us. And then we ask a question, who should be responsible? Because if this small card is not working, is it a company who issued the card, bank, or a store which didn't pay bills for the internet services maybe? So this is a question, who should we ask to be responsible for that? And it's a little bit like to say description, how we also look from the lawyer side to new technologies, which relates to decentralized finance. So again, the aim is to serve customer better, to provide alternatives to this conventional financial system, which we have today. So this is classic that deserves a lot of prize. So we today, if we speak about centralized financial ecosystem, so it's we have centralized governments, we have licensing, registration, AML, we have know your client requirements, we have very sophisticated regulation of the consumer protection, intermediaries, taxes, responsibility, legal remedies, enforcement, insolvency remedies. So everything is quite organized and structured. If we look at the decentralized finance, then we see this new trend, decentralization and disintermediation. And this decentralization actually covers three main dimensions, which is risk-taking, decision-making, and record-keeping. And DLT, such as blockchain technology, can, as a benefit, can reduce transaction costs, can generate distributed trust, provides transparency, and empowers decentralized platforms. Being part of the international organization, which is Institute for the Unification of Private Law, it is an independent intergovernmental organization with 63 member countries. And the main area where we are working is unifying private law, international business law. And we have done lately a lot of work and adopted legal instruments in the capital market, conventions that I will refer a little bit later. But today in our agenda, we have also an ambition to elaborate a guidance legislative document, digital assets in private law, in order also to come up with the principles that would be a base for inspiration for national legislators later on work on national laws regulating digital assets and also related to decentralized finance. So we are working together with other international institutions like United Nations Commission of International Trade, ALI, which is American Law Institute, ELI, which is European Law Institute, and also other institutions like International Telecommunication Unit also is working to the issues from the technical and standardization side of the DLT technology. What is the content? So the idea is to develop principles relating to the legal nature, transfer, and use of digital assets. And first of all, we have to start with the legal taxonomy of digital assets, definitions, categorization, and what actually we would like to understand worldwide in a common way, what is a digital asset. Analysis focusing on proprietary interests, specific issues arising in various contexts such as secure transactions, applicable law in cross-border transactions, the legal position of intermediaries and insolvency issues. And within our mandate, so we can only address issues relating to the private law, which is issues relating to the contracts involving digital assets. And also just being inspired by the previous speakers, I would say that yes, the decentralized finance system is like a blood circulating system where we have inside this small oxygen, which are these crypto assets running. And so the smart contracts is this engine, which is pulling these digital assets and crypto assets, in this new blood circulating system. And that's why also these contractual issues related to smart contracts are very important. So legal nature of proprietary connection between digital data and another asset, accommodation of disparate types of assets and technologies, provision of digital asset custody services, taking of security over digital data, the legal treatment of digital assets in relation to insolvency proceedings. And this we already see that we have lived through some experiences when the traditional conventional courts were asked to come up with the explanation or applying existing rules to the issues arising from the cryptocurrencies in insolvency cases. And we see that the first was the Court of Japan, which actually came up with some kind of first definition, what is a virtual asset and virtual currency. Remedies and enforcement issues, and law applicable to issues relating to digital assets. Of course, the value, as I mentioned briefly before, of the UNIDROIT Institute is that we have an experience. We have done already some work in the capital market, and I'm just mentioning two of the latest international legal instruments. One is the convention, UNIDROIT Convention of Substantive Rules for Intermediated Securities, adopted 2013. In 2017, we adopted UNIDROIT legislative guide on intermediated securities. So which also the idea is when elaborating the new guidance document, also to see the synergy and maybe to adapt also existing legal instruments to the new challenges of the DeFi. What are these legal challenges already detected? So this is contract law issues. With respect to digital assets, issues of holding, transfer, and collateralization of digital assets and legal remedies. Acquisition of property rights in digital assets, which is originally by issuing or by a derivative acquisition upon disposition based on smart contracts. So there's a question about fungible and non-fungible digital assets. Of course, the term digital asset is very wide, and we can also include like digital items like crypto art and crypto gaming tokens. So it also should be like a taxonomy and categorization and of these terms. Application to digital assets of legal concepts of recovery and liability. Digital assets custody services, intermediaries, securities intermediaries, how to deal with title transfer, trust, and or bailment, agency of contractual issues. The enforcement of judgments over the digital assets, this is also very challenging. How can we ensure? And also, especially if we look at the issues arising from data protection, and one of these almost human rights that we have in data protection is the right to be forgotten. So if we have, for example, how to execute, how to enforce this rights, it's also from the legal side, it's very challenging how to regulate and how to implement once it's also regulated. Dispute resolution techniques, the tracing and recovery of certain digital assets, cryptocurrencies and other, determination of the applicable law, party autonomy, to choose applicable law and governing law of the contract. These are like previously issues, but UNIDROIT will be covering in the new legislative guidance document. What is going on today in the different parts of the world is, as we see, so countries are taking different approaches. Some of them making really favorable legal regime and inviting and supporting new technologies. Some countries are having relatively hands-off approach or wait and see approach, and some countries are choosing to ban or banish cryptocurrencies in some of the DeFis. So European Union came up at the end of last year with the announcement that, of course, future is digital, and so all the rest policy should be adapted to this vision. And so there is a new document which is called Markets and Crypto Assets, which will also come up with the general requirement how the legislation within the European Union countries should be adopted. So, and also to regulate currently this out of scope crypto asset types such as stable coins, as well as crypto asset service providers referred as a CASPs. And just last week, I found that came out also a new study done by European Parliament, also trying to show a roadmap where the Parliament should focus on making European laws. And it's a study called Liability of Online Platforms, which is, and the main idea, which I liked it very much, this is encouraging the industry to start self-regulation, maybe not to apply already this command and control concept in regulating DeFi, but primarily to invite the industry to start self-regulation, which actually I would say it's already working today. So in our hosting country, so Dubai has a motto that what is good for business is good for Dubai. I think it's very important, and that's why probably we have also this possibility to talk about these new technologies. So there are amendments to existing federal law, so definitions of the basic terms, mandatory licensing. What I also found very interesting that this is a very detailed, sophisticated requirements regarding disclosure requirements, which we have to put. Switzerland, I will go very fast because I'm out of time remaining. Okay, I still have a little bit time. So Switzerland is one of the most important jurisdictions for initial coin offerings and security tokens offerings. And also last September, so the new bill was adopted, DLT bill, and some parts of the newly adopted bill came into force 1st of February, and the rest is expected to be effective since from the 1st of August of 2021. And also the new category of uncertificated security ledger-based securities is regulated and introduced. There is a proposal to establish uncertificated register securities and a new license for DLT trading facilities. And the specific regulations on the segregation of crypto-based assets in the event of bankruptcy. So also that's very important. So in many countries already issues which relates to bankruptcy are quite good regulated already. United States of America, so is also different states are having different approach. So Wyoming, probably, since you are in the business, you better. This is one of the states which have very favorable regulations, and they're trying to promote technology. And they try to extend cryptocurrencies from the state securities law and money transmission statutes. Ohio became the first state in the United States to start accepting taxes in cryptocurrencies. However, Iowa introduced a bill that would prohibit the state and the political subdivisions of the state from accepting payments in cryptocurrencies. And the latest document is from the December 2020. This is a notice of proposed rulemaking requirements for certain transactions involving convertible virtual currencies and digital assets. And also there's a proposal to cover convertible virtual currencies under the term of monetary instruments and to be governed mainly by the Bank Secrecy Act. And of course, very detailed AML, KYC, CIP requirements are proposed, and reporting requirement. And reporting is actually is offered to have from every transaction which exceeds 10,000 United States dollars. Japan, so as I mentioned already, is the first country which was asked, the judicial system of Japan was asked first to come up with some definition of the virtual currency. Today, so exchanges have to be licensed as crypto asset service providers. In May 2019, the new amendments to existing main laws were adopted, which came into effect 1st of May 2020. And what is important that also the term virtual currency established by the court originally has been replaced by the crypto asset. Limitations are to be placed on derivative products like margin trading. And what is also very unique that it is now a punishable offense to spread false rumors about the cryptocurrency. Of course, trying to introduce a little bit with the different countries, I tried to pick up some interesting moments because probably you working, you maybe already know many issues more in detail. Singapore is also the country which is welcoming technologies and making very favorable jurisdiction for that. So in January 2020, the Payment Service Act came into effect to regulate traditional as well as cryptocurrency payment and payments and exchanges. Local exchanges can list cryptocurrency derivatives and can trade such financial products. And crypto company is a company that mine and trade cryptocurrencies and are subject to normal income tax rules and have to obtain a license. There is very detailed AML and CFT requirements, and the term digital payment token also referred to virtual currencies. What is the future of DeFi and self-regulation? So DeFi has not reached its full potential, of course, because it's just on a way to run. So and I fully agree that today we are living like in two parallel worlds, where the conventional centralized financial system is working. And they, of course, they're not looking to the other parallel world, the decentralized finance, because there is a competition. Of course, and that's why we have to also see which is the right way how to encourage collaboration between these worlds, how to find a common language, because right now sometimes these two worlds speak in their own languages and we do not understand each other. So, but of course, you know, there is a potential. I strongly believe as well that the future is digital and that the DeFi has a great potential. But we have to, nevertheless, solve the issues raising from the fraud, volatility, usability, and regulatory uncertainty. DeFi so needs to create this healthy ecosystem, how to serve customer better, and encourages responsible innovation. Industry is encouraged to start a self-regulation, which I think is already ongoing. And one of the benefits is also when we try to describe DeFi is said that it's good because it's very transparent. But at the same time, we can see that too much transparency also may jeopardize privacy. And we see that also data protection and privacy rules also are challenged and supervised when we talk about the involvement in decentralized finance. DeFi may lack accountability. Who should be held accountable for potential wrongdoing on the centralized financial ecosystem? The same as I, at the beginning, made this description of the credit card. So when it's not working, who should be liable? To whom I addressed my claims? And the operations of DeFi tend to rely primarily on the rule of code rather than human judgment. So we are proud to saying that smart contracts will replace lawyers, but we lawyers also want to see our profession to be needed. So we do hope, but closing my speech and introduction to some of the legal challenges, I think that also, so we lawyers are also very flexible, and so we will probably find our way, this human touch, even it's a very technical already. So thank you. So it was my pleasure. So I would be happy to answer questions if you might have. I wish a very fruitful Congress and keen to listen to other presentations. Thank you.